Robert, I believe you are on the call now.
I am.
Okay.
Again, to the participants, sincere apologies for the technical glitch in having Bob join. Bob, I already gave an introduction to you, so welcome aboard. I know you have a prepared presentation that we will unfortunately not be able to share, but the essence of the presentation I'd like to run through in a series of questions that the DIB would appreciate your advice on. So let's fire off and get going. Stacy and DIBCAC clarified this, but I think that participants today may be looking at an independent analysis of, look, what are the requirements that I want to be compliant with? How important is it for me to be compliant with requirements? And hear from a private sector lawyer who understands these controls. So with that in mind, let's fire off. The first question for you, Bob, is, are defense contractors required to meet the 110 controls of 800-171 if they have an existing DFARS clause in their contract?
They are if they have controlled unclassified information. There can be circumstances where a company will see the 7012 DFARS clause in its contract, but not actually have any covered defense or controlled unclassified information. But if that clause is in your contract, then you are required by 7012 to have adequate security to protect the confidentiality of that information. And adequate security is to be provided principally by satisfaction of the 110 discrete controls that are in NIST Special Publication 800-171. Let me add, though, quickly that there can be some companies who think that what they do is too small or perhaps too insignificant, and they might feel that no one will care or pay attention to them. Unfortunately, the experience for some years now has been that there's a range of adversaries who look to steal information, and they all too often are looking at what's been described as the low-hanging fruit. And here I'm referring to nation states who have done all too good a job in exfiltrating or stealing sensitive information. Just yesterday, I believe, the Secretary of the Navy, Carlos del Toro, cautioned the defense industry to be very protective of company data. And he said that adversaries, principally China, really are out there and they're really trying to get your data. And the truth is that companies in the defense supply chain are inviting targets for adversaries such as China, but in addition, they are especially tempting targets for ransomware actors who may be criminals just out for a buck, or may be affiliated with nation states. Compliance is part of the picture, and 7012 imposes a compliance obligation. But prudent enterprises in the DIB are best counseled not only to be compliant, but to be thinking of ways in which they can adopt security measures that will make them more robust in the sense that they are resistant to successful attack and exfiltration, and more resilient, meaning that they have a better ability to recover and restore operations without loss of data more quickly.
Well, thank you. So, Bob, there is a DFARS clause 7012 C through G that imposes requirements on contractors, which basically, in simple terms, as we understand it, says the following: look, if there's a breach, you got to report it, and then you're supposed to provide information associated with the breach. So suppose that there is a contractor and they are a victim of what you just spoke about, a commercial, ransomware attack or a breach. How does that commercial ransomware breach suddenly now spill over into compliance land, particularly with obligations under 7012 and specifically C through G?
Well, it definitely does. I don't know whether it came up in your introduction, but among the things that I've done for the MITRE Corporation is to study ransomware and relatedly cyber insurance for the last year. There's a number of different ways in which ransomware attacks are mounted. But typically, they will involve, at the very least, locking an enterprise out from the information system on which it hosts data. Just that becomes an event, I believe, that is reportable under the C clause of 7012. Increasingly, we see this form of double extortion, where the first level of the extortion is to deny you system access, and the second is to threaten to put your data up for sale on the dark web or to provide it to competitors or hostile parties. You can see that if your access to your system and its data is compromised, and if you are told that the criminal has exfiltrated, stolen your data, and has its own copy of it, well, that absolutely is an event that is reportable to DoD. DoD's interest in the reporting primarily is to know what information relevant to its missions has been compromised and how might that affect its ability to perform those missions. If DoD is concerned about what you have lost, it's certainly possible that they would want to conduct some assessment of your controls and practices to understand how this happened. They have the right to do so under the clause. And if it turned out that you had valuable information and had done little or nothing or acted recklessly not to protect that information, there could be contractual or other compliance consequences. On the ransomware side, though, we have to appreciate that the biggest danger to a victim, including those in the DIB, is that they'll be denied access to their system and be unable to continue their work as a contractor. It's also all too common that a ransomware attack is followed by a string of expenses that mount up very rapidly, as well as longer-term liability that could come to be a very large amount. And there are instances where participants in the DIB and other small and medium-sized companies have found that they can't afford the response of the ransomware or the legal fees of the forensic time. And there are instances where the loss of business continuity produces an unrecoverable financial loss. So companies really do go out of business. And so what I've been counseling companies lately is, of course, to be focusing on compliance, and that means 171, 7012. But the best reason to be smart about security and to get on with the job rapidly, in my estimation, is to protect your enterprise at the whole level, to protect your business relationships, both your customers and your clients, and then to be sure as well that you are in compliance.
Thank you. So Bob, per your guidance and that of the DoD earlier in today's webinar, enforcement of 800, 171, the 110, clauses is in effect. That's the law, but it is essentially implemented by a company, and the contractor then self-assesses themselves. Could you speak to, what level of sign-off is required by a contractor that has gone ahead and implemented DFAR 7012? Is it just the IT managers? Does it require executive sign-off prior to being put in the SPRS database? Your comments on that would be very helpful.
So first, it's true that self-assessment forms what is the so-called basic level of assessment under the 7019 and 7020 clauses, which are in place and are expected to become final in December. A basic assessment is not just however a company chooses to look at whether it did or did not satisfy 171. All levels of assessment, basic, medium, and high, including self-assessments, they have to be done using a specified methodology, the DoD assessment methodology. And it tells you how to look at things and the relative score or importance of each of those 110 requirements. So when we think about assessment, and let's talk about SIPRs. At the very least, under 7019 and 720, any company that is doing business with DoD and wants to have a contract, and this is all assuming that you have the 7020 clause after November 30, 2022, when it became effective. You have to prepare that self-assessment using the methodology I described. You have to apply it for each of the covered contractor information systems in your business. You have to provide the cage codes for the businesses in question. You have to provide your total score, and you also have to provide a date by which you expect to close any of the gaps that you've identified. I believe that there is an element of representation made when you make a SIPR submission. We know for a fact by regulation and other DoD actions that contracting officers are supposed to look at and consider a SIPR score and making a determination whether an offeror has present responsibility. My recommendation is that any score that is submitted to SIPRs ought to be one prepared by or signed off on by an executive. And as a matter of governance, risk and compliance, I think it's very important for executives to have confidence that the score to which they are attesting is one that would withstand scrutiny if it were to occur. The two DCMA DIPCAC persons, William and Jennifer, who spoke before me, they talked a little bit about this medium assessment. Well, beginning in March of this year, DIPCAC announced that it was going to start to make random contact to companies who had submitted a basic self-assessment score. And they were going to look at the SSP of those companies and perhaps ask for other documents and discuss whether the score that was submitted was consistent with the documentation that the company actually had. And the initial results of that exercise have not been especially encouraging. One of the slides that may have been put up earlier showed that essentially the average score for 16 companies who had a medium assessment, I think they had reported an average score of plus 57, but after DIPCAC looked at their actual SSP, they came up with a different score of about minus 57. That's a big difference between what you say you have and what you don't. And there was, I think, one instance, at least one, where a company reported it had the perfect 110 score, whereas actually its documentation supported no better than the lowest conceivable score, which I think is about minus 203. Well, as was also said by the DIPCAC persons, it can be a serious matter to misrepresent your compliance. There may be areas where you make an honest mistake, but if you are reckless in disregard of your actual compliance, if you attempt to check the box without having the SSP and other documentation to support it, the risk is increasing that you will be found out by DIPCAC. And as was mentioned, they can make a referral to the DCMA Contract Integrity Center. And as a lawyer who sometimes defends companies who are under investigation by DCMA or DOJ, I can tell you that that experience and exposure is not something that any prudent company would want to risk. It's a better business decision to protect yourself and the value you are to your customers, employees, and stakeholders. It's better to spend the money to do that and protect yourself and be in compliance than to take the risk of a ransomware attack producing a fatal disaster or compromise of your information that would damage DoD, or the risk that you might be found by DoD or DOJ authorities to have been deliberately neglectful of your obligations.
So Bob, we have a limited time left. In the 3 minutes that are left, I have a two-part question. Now moving on to sort of business risk associated with it and competitive advantage. What would you characterize is the significance of the SPRS score to a contractor's competitive stance on bids? Could it be used much like an SAT to compare companies one against the other?
That's a great question. DoD put out a memorandum to contracting officers on June 16, 2022. If or when you distribute my slides, there's a link to it. And it emphasized again that DoD contracting officers are supposed to look at the SIPR score. It is increasingly important to prime contractors across the range of DoD activities to know that they have a secure supply chain. It's also important that to those prime contractors to have confidence that you as a smaller business will be able to perform, will not be taken out of business by ransomware, and will not be a means by which a ransomware or nation-state attacker is able to penetrate the supply chain, damage the continuity of goods, or even find a way to lodge an attack at the higher tiers. But to simplify this, I would say this: prime contractors are increasingly insistent that their suppliers do more than assert security. They will want to see some form of demonstration. I am hearing reports or instances of where prime contractors want to know what the SIPR score is of their suppliers. Now, that SIPR score itself has some value because it's what a company has submitted to DoD. But I expect that an increasing number of primes will want more than that. Just as insurers now are doing substantial due diligence before they will write a cyber insurance policy, I would expect that much of the supply chain will see increasing requirements of demonstrated cybersecurity and even requests to review system security plans. I appreciate those things are considered highly proprietary, but from the standpoint of a prime, they will want to know better than just that self-attest that they are compliant. Eventually, when the CMMC ecosystem is sufficient or complete, we're going to accumulate pretty sizable numbers of entities at every size who will actually have been through an assessment and received a certification. And when you have that certification from CMMC, or if you have other counterparts to such a certification beforehand, that's a powerful demonstration to a prime contractor or to a government customer that you should be the company chosen to work with them on sensitive projects.
Well, thank you very much. It's on the dot 2:30. We appreciate, your insightful comments and perspective as a lawyer that's involved with compliance and cybersecurity. We will be sure to, include your presentation, which was very helpful, and look forward to actually, redoing this session at another time so that the audience has a chance to, get your comments and your slides, together.